Hey, well, good morning. Happy to be here. Dave and I have been, between the two of us, have over 50 years of patent experience. And so hopefully we can share something that will be useful for you in thinking about entrepreneurial activity and startup company in this area of therapeutics. And so just especially since it's such a small group, I would love, if you've got any questions as we're giving the presentation, feel free to speak up. You don't have to wait till the end, because we want to make sure this presentation is relevant to you, right? So if we're not covering things that you're interested in, feel free to ask. So this is related to intellectual property and specifically patents. So okay. So as kind of an initial observation, why do patents matter? So number one, patents give the patent owners exclusive rights to the owners, which incentivizes innovation and protect new inventions legally. So they also support investment, as was alluded to in the last presentation. This exclusivity encourages investment in the research and development by providing kind of financial and legal security. So gives the owners this exclusive right to prevent other people from playing in that same space. With patents, you can also license and create partnerships and give competitive advantages in commercial markets. And as historically, company value, according to a lot of data, is anywhere from 80 to 93% of many companies resides in intellectual property, which can include patents, trademarks, copyrights, trade secret kind of information. And so patents act as a valuable asset that can attract investors and enhance value. So what is a patent? So as I mentioned, the patent grants exclusive rights to the owners to protect their invention from others making, using, offering for sale, or selling the invention for a limited period of time. Now you notice there's something missing there. So a patent gives you the right to exclude other people from doing those things, but it doesn't necessarily give you the right to practice your invention, which is maybe a little counterintuitive, because there might be other people's patents that could potentially prevent you from doing what you would like to do. But this exclusivity lasts for, the default is 20 years. Sometimes that patent term can be extended under certain circumstances. And so you've generally got about 20 years to take advantage of your patent, after which it's sort of a free-for-all. It's open to the public. So as part of this, patents are basically a contract with society for full disclosure of your invention to enable other people to kind of use that invention. You get a temporary monopoly for that idea. So you've got to publicly disclose the details of your invention so that other people can build on those ideas. Patents are also, they're legally enforceable. It can be licensed or sold just like any real estate, for example. They provide these intellectual property rights. So how do patents work? In terms of in order for you to secure a patent, you must show that your invention is novel, non-obvious, and is fully described. And in terms of the patent statutes, that is referred to as written description and enablement. So you have to enable somebody skilled in the art to reproduce your invention. And we'll talk a little bit more in a little bit more detail what that means in here in just a minute. So who is entitled to secure patent rights? So under U.S. patent law, the initial ownership rights in patents default is to the inventors. So inventors are entitled to ownership of patent rights. However, as subject to employment obligations, so generally speaking, employees contractually under either state law or their actual employment agreements are generally obligated to assign those default rights that they acquire in the inventions that they develop to the company. There's something that I actually ran into just a few weeks ago were importance of documentation. So one of the things that you want to be careful of is in the absence of documentation. So if you have sort of an informal partnership, that can be dangerous because there's no actual written contract obligating somebody to assign the rights to a company. So if you have multiple inventors, you could have multiple ownership issues. So it's important that you document your developments in the invention, and so you can know who contributed what. And one of the things to keep in mind is that there is a difference between authorship on, say, a technical journal paper versus inventorship on a patent. So sometimes you might allow a lab tech rights as an author, but that does not necessarily entitle them to be listed as an inventor. And we could go into more details on that difference, but basically if they need to have contributed something inventive to one or more of the claims in a patent application. Okay, so the legal standards I mentioned, there's a utility requirement. The invention must be practical and useful. You can't patent abstract ideas or laws of nature. Novelty is the invention must be new and not previously disclosed in anything that predates your filing date. In the U.S., there is a 1-year grace period for your own work. Many foreign countries do not have that grace period. So as a general rule, it's important to have your patent applications on file with the patent office before any public disclosure. And that's an important rule to keep in mind because your patent rights can be forfeit in many countries, and including the U.S. after 1 year after such a public disclosure. The inventions must also be non-obvious. Now, as you can imagine, obviousness seems a little subjective, right? You can imagine what's obvious to one person might not be obvious to another person. There are a lot of legal standards, and you could spend quite a bit of time talking about that. But at the end of the day, the invention needs to be a non-obvious advancement, and to somebody of skill in the art. And then the last requirement we'll talk about here is enablement. That patent applications need to disclose enough information for somebody skilled in the art to reproduce the invention. So just as a little example here, so patent claims, when you're thinking about inventions, and when it's a little bit different than maybe in academia. When you're thinking about patents, we think about patents in terms of genus or sets and subsets of ideas. And so in the patent claims, we refer to those as independent claims, which are the set, and then dependent claims are subsets of that broader inventive concept. So in practice, an infringer needs to include each part of a claim in order to infringe. And claims are evaluated for infringement individually. So for example, at the end of a patent, if you've ever seen a patent, they'll have multiple claims, claims 1 through 20, and claims 1 and 10 might be independent claims, and the other claims would be dependent claims. So as an example, if claim 1 was a therapeutic composition comprising components A, B, and a carrier, an infringer would have to have A, B, and a carrier in order to infringe. Now, claim 2 is a subset because it refers back to claim 1, the therapeutic composition, claim 1, wherein component A is X, Y, or Z. And so it's theoretically possible that somebody could infringe claim 1 but not claim 2. So that's just kind of an example of how claims work and how we look at things. So we're always looking at things in terms of genus and genus and species, or sets and subsets. Okay. Part of the value of patents comes from this market exclusivity. So it gives companies the right to exclude others from from unauthorized use. So again, that making, using, selling, or offering for sale of the patented invention. These rights can be licensed, which licensing may basically giving a third party permission to use your patent rights. And they can be sold or used as collateral to raise capital. And they can generate income through royalties or financing. So patents are important in forming partnerships, mergers, acquisitions, and providing leverage in litigation. And again, there's a lot we could talk about there in terms of leverage. But so patent process overview. As some of you may be familiar with, there's provisional applications, non-provisional applications, continuation and divisional applications, and international applications. Provisional applications are just temporary placeholder applications that last for 1 year, and you have to be very careful about that. Some people think that provisional applications are some sort of magic way to get a cheap application, and you've got a year to fix it up. And there's some truth to that, but the problem is it can create a false sense of security. So you've got to be very careful and communicate clearly with your patent attorneys about your strategies to see whether or not that's really a good idea or not. Because provisional applications can be filed as sort of a cover sheet type application, which is very minimal, and you kind of get what you pay for. Or you can file kind of a provisional application as sort of intermediate, kind of starts putting things together legally. Or you can file a provisional application that is very robust and looks practically the same as what you would see in a non-provisional patent application that would eventually get examined by the patent office. So there's pros and cons to provisional applications. So just be aware that it's not a cheap way to preserve all rights. It's a good starting point, but just be careful about those. Non-provisional applications are the ones that actually get docketed and examined by the patent office. So when you file those get queued for examination in front of a patent examiner that theoretically has experience in that space. Oftentimes examiners think they know more than they do on the technical side. So sometimes there's some education involved in educating examiners about your invention and maybe differences from other prior art. Continuation and divisional applications are a way that allows us to, oftentimes the patent office will say, hey, we're not going to give you everything you wanted in the initial application. We'll give you this little piece that's maybe a preferred version of your invention. So you say, okay, I guess that's good enough. We'll take that so we can, say patented, or we can get some additional funding. So oftentimes investors are much more excited about an issued patent than a patent pending. And so you get this narrow issued patent on the core invention, but you can go back through a continuation and or divisional and try and get the rest of it through subsequent applications. And those will maintain, it's as if they were filed on the earlier dates. International patent protection, again, there's a couple of different mechanisms to protect your invention in foreign countries, but that's a whole nother discussion. But the idea is that you have to worry about the filing deadlines to make sure that you secure your rights in time. So as a general rule of thumb, what you would go through in terms of the steps to obtaining a patent application is that you would approach a patent attorney and talk about your invention and evaluate options, and oftentimes you'll also do a review of the literature to see what else out there is similar. And then assuming that it looks like there's some opportunity there to secure a patent application, you would prepare and draft an application that includes a description, drawings, and these patent claims that legally define the invention. So again, those claims are, you kind of imagine that's the legal definition of your invention, what you're claiming exclusive rights to. And the drawings and the rest of the patent application are just there sort of to support those claims. So that those claims are sort of the heart and soul of a patent. Yeah.
So at that point, like with these drawings and descriptions, how much must one first speak to actual feasibility or scalability or what? I mean, we're keeping designs updated and it may or may not be really feasible or scalable.
Right. So that's a good question. I think as a general rule of thumb, patents don't have the same sort of expectation of actual data. Now, it depends on the nature of the invention, but what again you have to illustrate to the patent office and to a future court, if it gets into litigation, that you had possession of the invention. Right? So you said, hey, I really actually invented this. And so that generally requires sufficient detail to, again, enable somebody to reproduce it. Now, if you disclose things in your patent application that don't actually work, that's not necessarily fatal to a patent. But as long as you've disclosed things that do work, you should normally be okay. So oftentimes, because patent applications generally are fairly early on in the process of development, maybe the invention is not 100% mature, right? So sometimes you're guessing a little bit, you're extrapolating somewhat, and that's acceptable as long as it's reasonable, right? So, yeah.
Can you explain how the path for solution help us?
When you start up a company, right? So in the university setting?
Yeah. How does that just put?
Yeah, so again, it starts with the ownership. So you kind of identify who are the initial inventors, and are they under any obligation to assign to the university, right, or to the institute, and so that would govern how it was handled from that point. Now, if it's under the university, then you would go through the TLO and disclose the invention with them. They've got a system. I don't know if you're familiar with that. They have an invention portal system to allow you to disclose inventions. And then they kind of shepherd you through this process. And typically what happens is that the TLO would kind of initiate this patent process. And then if you wanted to do a startup company with that technology, they would license it back to you. Okay? So, and that's a good discussion for Jason or somebody else from the TLO. So, questions? Yeah.
And secret question.
Yeah, go for it.
Is invention a new method, new result? For example, I have two scenarios. If I would have unique patient population, I use standard method and then create this test. In the second scenario, I create a new algorithm using it on public data, creating a new test. But which one?
Potentially all of the above, right? And I think Dave here is going to talk about that in a little more detail as applied to therapeutics and diagnostics. But yeah, as a general rule of thumb, most of those things would probably be candidates, right? So you can patent compositions, methods of diagnosis, methods of treatment. Now, methods of treatment are a little tricky in some foreign countries, but the U.S., they're fine. But yeah. Okay. And so once we file a patent application with the patent office, it gets reviewed and scrutinized, and patent examiners feel obligated to justify their job. So you'll get some arguments from them, no matter how novel or not obvious your invention is. And there's some back and forth usually with that. And then once the examiner agrees that it's allowable, then you should get a patent as granted. So I'll turn the time over to Dave. Thanks.
He'll be back. Thanks for this opportunity to speak. Patents are something that put most people to sleep. I really like patents. I love intellectual property, and I love speaking with people and teaching them about intellectual property and the value. And in the world of therapeutics, I like to think of patents as the interstitial material. They are the glue that holds the entire therapeutics industry together. And I love a couple of the things that Randall said earlier, that first he got patents, and then he did more work and he got more patents. And he also talked a lot about building value. And while it's not exciting or shiny, the patents are definitely where a great measure of the value resides when you're talking about commercializing therapeutic products. I wanted to touch, because we've got some time constraints, on just a couple of points with respect to the importance of patents in therapeutics. And mostly I wanted to talk a little bit about a couple of areas where patents can be challenging. And these are things to keep in mind as you're doing your diligence, like Randall said. Again, hopefully as you're doing your diligence, you're asking yourself or your patent attorney, well, can I really protect this? Is there a commercial opportunity? Because in a perfect world, medicine would be free and would be open to everybody. We're not in a perfect world, and if you can't commercialize your therapeutics, then the cost to bring a therapeutic from discovery all the way through commercialization is significant. And if you can't, pay for that, then there's no more new therapeutics. So a couple of considerations are, number one, subject matter challenges. And I want to talk about 2 points. And the first one is with respect to diagnostic tests. And with diagnostic tests, there are some limitations on what can be patented and what can't be patented. And these come down from the Supreme Court of the United States. And the first case is Mayo v. Prometheus. And in this particular case, Prometheus had developed a drug, and they had developed a diagnostic test for determining the drug's effectiveness so that you could measure appropriate dosing. The diagnostic test turned out to be monitoring the metabolites generated by the drug. And the Supreme Court said, that's very nice that you're doing that, but that's a natural result of what you have done. And so from the standpoint of protecting that as a diagnostic tool, that's not available under the patent laws of the United States. The second one, which you may be more familiar with, is the Myriad Genetics case. And in Myriad, Myriad had claims in their patents that were drawn to the BRCA1 gene, certain segments of the gene, and also to methods of using the gene to identify patient risk for developing certain breast cancers. And the Supreme Court of the United States determined that the claims to the method of treatment were fine because it was a new way to use this information, but that the claims to the gene itself were something that was found in nature. And that is something that the patent laws exclude, is you can't patent something that is already found in nature. So, for an example, a native DNA sequence can't be protected. A cDNA sequence, something that is synthetic, artificial, can be patented. Something that maybe is concentrated or augmented, perhaps also patented. Compositions including those materials can be patented. But the items found in nature themselves, the native object, cannot be patented. So that's also something to keep in mind. One other thing I wanted to touch on, my practice involves a touch of the regulatory scene. Randall mentioned the sort of well-trodden pathway through the FDA. And there is one, and it has to do with the Hatch-Waxman Act, which grants exclusivities for certain compounds, certain treatments. Did you get the orphan drug designation on? Yeah. So orphan drug designation is 7 years worth of exclusivity. There's an exclusivity for new chemical entities of 5 years. There's a few other exclusivities. These exclusivities are not tied to patents. These are exclusivities granted by the FDA itself. So whether or not you have a patent, you may qualify for this type of protection, where the FDA won't consider any competitors' or a generic drug application during the period of exclusivity. One of the things that Eric has been talking about, and again, because we're short on time, I'll sort of just skip through this, is strategies for therapeutic patents. And again, as a patent attorney who's been practicing for 25 years, I believe strongly in looking at the whole possibility. Broad claims, if you can get them, narrow claims to cover the product itself. One of the things I always try to look for are what I call scientific bottlenecks, where if there is really no other way of doing something, then medium scope of coverage to that mechanism, that compound, that composition, that may be your most outstanding coverage possible, because it's more of a medium scope, so it's less exposed to an invalidity challenge, yet it's going to really effectively keep your competition at bay. And I think this is where I turn it back over to Eric. Any questions on therapeutics? Okay, thank you.
Okay, so just sort of some, in summary, sort of some just best practices. So I kind of alluded to this earlier. Just keep in mind, ownership is really important. If you're going to start up a business, make sure that any contractors, potential inventors, are under contract to sign their invention rights to you. Otherwise, you might run into issues down the road. Gentlemen's agreements are not enforceable, unfortunately. Just don't do it. Talk to an attorney before if you need to get that. So assignments of those rights are actually recorded to USPTO, just like real property. Patents, do's and don'ts. Okay, so just some recommendations. So prior to filing, do not display or discuss the invention at a seminar, workshop, poster presentation, or trade show, which is open to the public, or disclose it on the internet or other public venue. Disclosing an invention without a signed non-disclosure agreement could be a problem. So if you're going to talk to potential contractors, potential labs, it's important to get a non-disclosure agreement in place. So again, don't disclose your invention in any public way. That includes manuscript submissions or any internet Kickstarter kind of campaigns. If you distribute samples of the product to potential customers, that could be an issue. Or distributing brochures about the invention or demonstrating the prototype in a public venue. That's, again, avoid that, because as soon as you do that, if you do that before any patent filing, you're losing options. You're reducing the number of options you have. Do's. So file applications early. Look out for potential inventions. So anytime you're solving a problem, that's a potential invention. Get ownership agreements in writing. Don't avoid patent attorneys. So hopefully today you feel like you could come and talk to us. People like us. We're not too scary. And oftentimes I understand that the startup companies struggle with resources and money, and patent attorneys aren't cheap, but most of us will offer free initial consultations. And so you can talk to them and ask questions for an hour or so, just to kind of get an idea of what you might be, you might need to set aside in terms of budgets and times and sort of key things to worry about with your specific case. So drive your IP strategy. Don't wait for things to happen and follow. You stay in front of it and communicate with attorneys and make sure that your patent rights align with your actual commercial rights, because sometimes initially your patent and your inventions are in alignment, and over a couple of years of research, they start to drift apart. So it's important to keep that updated.